Good afternoon, all. I'm Ralph Rubner, the Associate Dean for Academic Affairs at the John Marshall Law School. It's my great privilege and honor to welcome all of you to this very, very special occasion in the life of the law school as we celebrate a number of very significant points in time in the history of the school. The 30th anniversary for the Center for Information Technology and Privacy Law, the 25th anniversary of the John Marshall Journal of Computer and Information Law, the 30th anniversary of the International Moot Court Competition in Information Law and Privacy Law, and the 50th anniversary that will be the hallmark, the appointment of Justice Goldberg to the Supreme Court 50 years ago, and he would have taken his seat the first Monday in October 50 years ago. And of course, today and tomorrow we will inaugurate this beautiful courtroom in his memory. If you get a chance today and tomorrow to take a look outside of the courtroom, we have a beautiful history through photographs of historical value that really depicts the life of Arthur J. Goldberg from his early days as an attorney in Chicago to the very proud fact that he was a member of our faculty back in 1938 to 1942, and after the Second World War when he came back. He was an adjunct professor in the late 40s and 50s, and of course we know the rest of the history. So we welcome all of you to join us on this very, very auspicious occasion. It is my privilege also to introduce Barbara Kramer, the daughter of Arthur Goldberg, who is with us today. And her two sons, Daniel and Matthew, will join us tomorrow. We are honored today to have so many prominent legal scholars and experts in the field of privacy law joining us, together with our own law school faculty, and a special welcome to the keynote address, Dr. Amitai Etzioni. I want to take this opportunity to thank a number of individuals who have worked hard to make this what we believe, a very successful symposium. First, Professor Leslie Reese, Director, Center for Information Technology and Privacy Law. Professor David Sorkin, the chair of this conference. Mr. Aaron May, who is in the back, Editor-in-Chief, Journal of Computer and Information Law. And I would also like to thank his entire editorial board, staff, and candidates for helping us out on this occasion. Thank you to all our visiting scholars, to my colleagues on the faculty, who will all be introduced to you later on. I would like to take this opportunity as well to thank the entire John Marshall Law School community, especially the staff who helped in each of these details. And again, too many to name today, but I want them to know that we appreciate all that they have done. And I would like to recognize Ms. Teresa Doe. She is the assistant to the Associate Deans, Smith and myself, who coordinated all of the activities that will take place today and tomorrow. Thank you very much. I wish to personally thank two prominent Chicago attorneys, Mr. Joseph Ament and Mr. Lawrence Glick, for bringing the Braun Endowment to us in 1989, this being the 20th year that we have had the Braun Memorial Lecture Series. Unfortunately, Mr. Glick took ill on his way here and could not be with us to bring greetings. We hope he will join us, and Mr. Ament will join us tomorrow for the other events. Let me just conclude with a few comments about the Braun Memorial Lecture. Joseph H. Braun graduated from the John Marshall Law School in 1918 and was married to Belle R. Braun for many years. He served in a number of positions of distinction within the legal community in Chicago. Much of his legal career was devoted to legislative issues involving the licensing of motorists and highway safety. He served the Chicago AAA Motor Club in a variety of positions, including general counsel, vice president, director, corporate secretary, and in 1984 elected director and general counsel emeritus. Mr. Braun wrote the legislation for the first driver's license law in Illinois, served as chairperson of the National Committee on the Uniform Traffic Laws and Ordinances, which developed model ordinances and statutes. Additionally, he served as legal counsel to the Illinois Conference on Highway Safety legislation and as a mentor to the Illinois Insurance Commission. In this capacity, he was instrumental in drafting the State of Illinois Insurance Code in 1935. Throughout his career, he exemplified the highest standards of our profession, a person of great integrity. Mr. Braun died on January the 27th, 1989. He made a very generous bequest to the John Marshall Law School in support of a future lecture series. The inaugural Belle R. and Joseph H. Braun Memorial Lecture was held in 1989. Since then, we have invited distinguished panels and speakers on topics including constitutional law, criminal law, environmental law, international human rights, individuals with the highest reputation both in the United States and abroad. So it is with great pleasure that we add this symposium in memory of Arthur J. Goldberg to this series. It is now my pleasure to introduce Professor Leslie Reese.
Thank you, Dean Rubner. On behalf of the Center for Information Technology and Privacy Law, our students, our faculty, our staff, and of course our fabulous alumni, I'd like to welcome you to this wonderful celebration of a multitude of anniversaries, not the least of which is the 30th anniversary of the Center. For more than 30 years, John Marshall Law School has been a leader in technology and privacy legal education, due in large part to a gentleman I would like to recognize today. The founder of the center, Professor Emeritus George Trubo. George could not be with us today, but it was his foresight more than 30 years ago that privacy was going to be a major driver in law, in business, in policy. And more than 30 years ago, he began preaching the need for lawyers to be educated about the impact of technology and privacy on all areas of law and business and policy. And so John Marshall became one of the first law schools in the country to offer courses in privacy law, in computer law, cyberspace, data privacy. We were the first to offer a specialized law course in e-discovery, ethics in social media, and the list goes on and on. And today we are continuing to preach the George Trubo message by offering an array of courses, LLM and MS degree programs, scholarly and CLE activities, and if you'd like more information about what we do, I would be delighted to chat. I'd also like to take a moment to thank Dean Rubner, Professor David Sorkin, of course Teresa Doe, Panayota Kellali, our Center Associate Director, Erin May, and again the entire staff, candidates, board of the Journal. This has been a tremendous effort, and I know you don't want to hear from me. You want to hear from more of our illustrious speakers. So with that, let me introduce my friend, my colleague, Professor David Sorkin, the chair of the symposium. Thank you.
Thank you, Ralph, and thank you, Leslie. Today and tomorrow, we will be examining a variety of issues relating to privacy law and policy as we track the development of privacy law from the late 19th century through the present day. We'll begin with a keynote address by communitarian scholar Amitai Etzioni, who urges us to consider privacy in the context of the common good. Thereafter, in session 1, we'll consider the legacy of Supreme Court Justice and John Marshall Law School professor Arthur Goldberg, in whose memory this courtroom is named. Justice Goldberg wrote a concurring opinion in Griswold v. Connecticut, arguing that privacy is a fundamental right under the Ninth Amendment. Later this afternoon, in session 2, we'll consider some historical perspectives on American privacy law. Tomorrow morning, we'll begin with a session on regulation and policy perspectives, followed by a discussion of technology and the future of privacy. The symposium will close with a convocation tomorrow afternoon at the Standard Club across the street. Justice Antonin Scalia will present the convocation address. I do have some brief housekeeping announcements to make before we begin the formal program. Please silence or turn off your cell phones. There will be a break with refreshments at 3:15 today and a reception at 5:30. Please note that food is not permitted here in the courtroom. There are restrooms located on this floor and on the 3rd and 12th floors of this building that can be accessed without key cards that will invade your privacy. If you plan to seek continuing legal education credit for your attendance, please make sure that you've signed in at the registration desk each day and pick up the CLE instruction packet. It's just outside the courtroom today and will be on 3 East tomorrow morning. You'll also need to sign the certificate of attendance and return it at the end of each day's program. And please fill out the evaluation form each day, as we would appreciate your comments. Materials from this symposium will be posted on our website at jmls.edu/Braun, and the proceedings will be published in an upcoming issue of the Journal of Computer and Information Law. We will be recording the sessions this afternoon and tomorrow morning. We have overflow rooms available in the event that this room fills, which it looks like it has, with both audio and video feeds up on the 12th floor of this building. We begin today with a keynote address by Amitai Etzioni, University Professor and Director of the Institute for Communitarian Policy Studies at the George Washington University. He is the founder of the Communitarian Network, a not-for-profit, nonpartisan organization dedicated to shoring up the moral, social, and political foundations of society. Dr. Etzioni coined the word McJob in 1986 in a Washington Post column. In 2001, he was named among the top 100 American intellectuals as measured by citations in Richard Posner's book, Public Intellectuals. He's written many influential and often controversial books and articles. His book, The Limits of Privacy, published in 2000, suggests that privacy must be balanced against other interests and argues that sometimes privacy of the individual must be sacrificed for the common good. Earlier this year, the Penn Journal of Constitutional Law published his article on privacy merchants and data mining, focusing on the growing threat to privacy from large corporations whose main function is trading in private information. Most recently, he has denounced consumerism, arguing that Americans' obsession with acquiring unnecessary goods and services has contributed to the current economic crisis. Please join me in welcoming Amitai Etzioni.
Thank you very much. Well, thank you. Thank you very much for a very generous introduction. I got a special dispensation of, because my age is above average, to be able to speak from here rather than standing there for the next 40 minutes. And I'm really very flattered by the opportunity to join this conversation. In my next life, I'm absolutely sure I'm going to be a law professor, because you're having all the fun. And meanwhile, you know, I have to do with sociology. And I remember very well my son graduated from the Kennedy School, and just didn't do much for him. But then he went to the Michigan Law School. And after 3 weeks, he called me completely excited. He said, "Dad, you know, in 1804, there was that fox in Virginia, and it ran from one state to the other and was died." That's the kind of excitement I sometimes miss. And I hope, you know, when I come back as a professor of law, I'll get some of that. What I'm going to try to discuss with you today, you really will need your extreme tolerance, because I'm coming in from a different language, from a different world, known as sociology. And I mean, by intruding into your space, you'll have to keep translating what I'm saying to kind of proper and logical thinking, known as law. And so I want to try to make 4 points, and looking maybe if that the chair allows for a few minutes of discussion, time allowing. What I'm going to suggest are 4 points. One is that if we protect social privacy too much, we invite more government intervention. A better way of putting it is to say it takes a village to prevent a crime. And the idea is that we are not just consumers in the marketplace and citizens in the state, but we also have a social fabric in our families, in our communities, our neighborhoods, in our voluntary associations, and these days in cyberspace. And we are each other's keepers, and we keep watching for each other. So informal social controls, trying to encourage good behavior and gently nudge us away from bad behavior. When we don't allow this to happen, when we have what should be called social failure, when communities get destroyed, or technological developments or law prevent us from being each other's keepers, then ordering society, which always needs to be attended to, falls to the government with its much heavier hand than that of informal social controls. That's going to be my one point. My second point, which I must say originally worried me, but then I found that my legal colleagues way exceeded my claims, and that the idea that there is such a thing as expectation of privacy should be allowed to die a quiet death. Well, it should be allowed to fade into the woodworks, I think is a gentle way of putting it. It's sociologically simply incomprehensible, but as I said, many legal scholars already pointed out in much stronger language, actually. It's circular, it depends on which public opinion poll you use. And I'm going to suggest instead that we rely on 4 criteria which will allow us to determine when it's reasonable to tilt to enhancing privacy even more, and when we need, I don't want to sacrifice privacy, but when we need to limit to some extent in order to serve the common good. And my third point is going to be that a free society can tolerate more surveillance the more surveillance is surveilled. If you indulge me, I'll repeat that. A free society can tolerate more surveillance the more surveillance is surveilled. What I mean by this, we tend to talk about the balance between the right and the common good, or rights and responsibilities, which are, I think, terribly important to communitarian thinking. But there's another balance, and that is between the supervisor and the supervised. And so we need to be sure that if you give the government any additional powers, that the oversight will also be increased proportionally, because the more we can be sure that what the government does with this new power is properly accounted for, properly used legitimately, the somewhat more license we can give the government to argue. And finally, as you kindly already mentioned, I found it to my surprise, I didn't expect it. I knew that the corporations, some corporations' only business is to keep dossiers on us. And I'm sorry, I can't resist. This is too good an anecdote for me. If you indulge me for a moment. Peter Swire and I have worked for a commission on information and security. And in one of those, they used to meet places like, Aspen, Colorado, Ritz-Carlton and such. And there was this dinner, and on this side, General Clark was sitting. And on this side, the technological officer in charge for the CIA. And Clark kept leaning over to him, who was working as a lobbyist for the corporation which keeps dossiers on people, and told the CIA, you should buy our stuff. And the guy at the CIA, he was the ultimate poker player, not a muscle move in his face. But every 5 minutes, Clark said, you have to buy our stuff. So I got interested what that stuff was. Well, they keep extremely detailed information about us, taken from private and public sources, practically on every American. What I did not realize, and I'm sure Marc Rotenberg knew that all the time, but I didn't, that they sell it to the government. So they have 35 contracts with practically every government agency, including FBI and the IRS, which they make this data available. Which means that when my colleagues in the ACLU would go to the roof, if the FBI kept a detailed dossier on every Americans, we hear very little, not nothing, but very little when a corporation does it. But it's one click away. One click away. And so the notion that we can look at that separately, that the government is not allowed, and this the private sector can do all they want, I think is highly obsolete. And we therefore need a whole new thinking. Where are we going to go from here? It's very easy to show in the cyber age that these borders are obsolescent. But how we apply the Fourth Amendment to the private sector is a challenge, I think, even for some of you. And so the only step I could make in that direction is to suggest that we add to this patch of laws which cover videotapes but not this, and financial but not that, a additional patch for the time being, just to bridge us, that will ban the dossiering and sharing and selling of sensitive information other than under conditions like consent and such. And that's the very important addition, that be illegal to use insensitive information to divine sensitive information. Because, for instance, what some of the web pages do, they're not allowed to trade in medical information, but they trade in all kind of information which in effect tells you the medical condition of the person. And then again, this distinction becomes meaningless unless we include not only the ban like financial medical information on trading with that without consent, but also on using commonly available insensitive information to divine sensitive information. These are my 4 points, and I rush through them. I understand the paper sooner or later will be available, just to give some more highlights. On the first point, so the baseline again is that we are social creatures who are very much depend on each other for our psychic well-being, that we keep looking at each other and screening our behavior and supporting those who behave and criticize those who don't. It's a very informal process, and therefore it's often overlooked, but a huge amount of social business is done it that way. If you think about for 1 second about parenting, there's very little the law requires the parents to do. But most of the other things people do because they love their children, all kind of, but also what will the neighbors say? And so in the neighborhood I live, if any of the children would throw a stone at a cat, let's say, on his way home from school, I would hear about long before he got home, and then it would be up to me to have a conversation with him. And when I must admit I allowed my loan not to be properly attended to, I very soon discovered that I either would be ostracized or I had to attend my loan. So it's a very rich amount of business, social business done that way, but it requires visibility. It requires that we know what people do. And if you put barriers between, what's behind the barriers we cannot see. We cannot see, we cannot control that way. So, in effect, the first to make that point very forcefully were feminists. Feminists attack the notion that your home is your castle, and therefore what's happening in your home is nobody's business. And they pointed out when there's spousal abuse, and I would add child abuse, even if it's in the home, and even if the curtains are drawn, we still have a right to know and need to know, and a need to interfere. You can say, well, why do you need a social fabric? Why can't I just rely on the law? If there's you hear, you see signs of abuse, you get probable cause and get the police involved. But the community can get activated much earlier, when there are much subtler signs of trouble before we get to the point where somebody is threatened or even hurt or killed, because its penalties are also gentle. And so if somebody is unduly criticized, they will live another day. That's not the same as unduly arrested. And so you think about the social mechanism of control as more subtle, more informal, more gentle, and earlier interventions, which, when they succeed, prevent all of the state. What I did in passing, I defined privacy as a social license to be invisible. So privacy means you can keep things from the public. You can do that for your medical information, you can do it for your financial, but for instance, you cannot keep from the IRS what your income is. So we define areas in which we allow people to keep things to themselves, and areas in which they prevent it from doing so. So step one, if we are going to minimize the state, we should not unduly limit social visibility of behavior. It takes a village to prevent a crime. And the paper gives 3 examples where we've gone the other, we debated this issue. One is now kind of dated, is when V chips were introduced to television sets. And now remember, these first of all are based on a voluntary code, though it's true that the industry introduced them under considerable pressure from the government, but the setting on the V chip is done by the parents. And the question, the people who treat minors as if they were individuals and installed with a full body of rights, objected strongly to limiting access to media through this instrument. A similar issue arises these days when parents introduce what's called spying technologies into their children's web pages. Well, that's the same issue today. No government is involved, and the question is, do the parents violate their children's privacy when they go and read their diaries, when they go and penetrate their Facebook page? And there you see the issue. If you maximize privacy here, parents cannot do their duty. If you maximize the intervention, children will not grow up to be able to dissent, to be individualized, to innovate. And therefore, the way I would look at it, it has to be age dependent. Instead of treating all minors as the very category, be surely for the 2 and 4 and 6 and I would say 12-year-olds, want to treat them with fairly unlimited oversight. And then they get closer to 17, 18, we want to slowly allow them more privacy. But the issue illustrates that tension I'm talking about between, we're in the social sphere now. And no government is involved. Are we allowing scrutiny? Are we allowing social control? Or we're setting barriers in the way of overseeing our children? The same issue arises even more complicated in colleges. Do colleges have a right to inform their parents when their children acting out? And we may fear they're going to shoot somebody tomorrow. And as you, again, I'm getting much too close to law here for me to go too far down that road, but as you all know, Congress first said no, the parents cannot inform, the colleges cannot inform parents about anything basically. Then they relented and they modified it that they can inform the parents under certain condition and introduced this beautiful distinction, which I think legislators can love and sociologists can understand, that you can do it for parents who pay. If parents pay, they get all kind of rights. But if they don't pay, sorry, mom and pop, you can't find out anything about the kids. That doesn't make a lot of sense. To those of us think that parents can nurture, can help to keep human beings being better than they would be otherwise. And if there are reasons to limit, like for instance, if the child declares that parents may turn violent and such, they will allow all children to exempt themselves, all students, even if the parents send in a check. So that is on my first point. I'm seeing I'm taking too much on each of these points, so I'm going to try to rush to the second one to get to the third and fourth as quickly as I can. So my second point concerned what should replace the notion of expectation of privacy. So again, in a sentence, the reason the sociologist has a very hard time following it, so to the degree that we talk about the subjective right to privacy, it's subjective, and I'm not completely clear why that should be one which would decide the policy. Professor Scalia and I both benefit immensely, if I may disclose that secret, from a Hollywood urban tale, urban myth, which I find unfortunately not true, but extremely useful for our analysis. And the tale is that when people relieve themselves in the pool, there's now a chemical which will turn the water around them ink blue. And now I would venture that people are not aware of this Hollywood story, have a very high expectation of privacy, almost perfect, that if they relieve themselves in the pool, nobody will know. They have a high expectation of privacy. Why should any judge in his right mind pay any mind to that as compared to the damage to public health or decency or whatsoever? For me, it's a very telling example why people say I have a right to privacy, or I don't see why it can be granted much status. As to polling the societal side of privacy, expectation of privacy, the first-year sociology student will ask, well, whose society are you talking about? Are you talking about Chicago or the East Side or Illinois or the gay community? Which community? So obviously, and how did the judges do that anyhow? I haven't seen them kind of studying a lot of public opinion polls. And I hope it doesn't guide them because, as we all know, wordings will change the results. So it's just very difficult for us, sociologists, to follow, and therefore the request for another criteria to decide what is reasonable and what is unreasonable in terms of this constant adjustment between privacy and the common good. So here we go back to the communitarian core thesis that our rights are inalienable and sacred. So is our commitment to the common good. So the conversation for sociologists is not the one, we have rights have been violated, how can we protect them better? The kind of typical dialogue, they're threatened. Our conversation is we have two completely legitimate concerns which sometimes come into tension. And the starting point of the conversation is, now what? And so to make the next step, you have to know in which direction we are tilting, because it changes the history. In North Korea, I don't have to worry about the state. I will worry only about individual rights. I won't even mention the other half of the story. In Japan, even, where the social pressure is so immense, I guess I only want to talk about women's rights, handicap rights, minority rights. But if you keep going from context to context, you'll find sooner or later communities in which the commitment to the common good has been so weak and so shredded that we have to ask, where should we go next? It turns out the answer is not the same for all areas. As I tried to show in The Limits of Privacy, in the area of medical information, and that was before 1920, I'm sorry, before 2000, we were way too indulgent to violation of privacy, and privacy surely was grossly violated for no public purpose by trading of medical documents. We corrected that since then. In other areas, as a famous example concerning HIV status of babies, I think we tilted in the opposite direction. We should have allowed violating the privacy of mothers in order to save the life of infants. So the four criteria come here to play to sort out what is reasonable. First of all, is there a problem? Because we don't want randomly to change tradition, to change legal commitments and normative agreements. That one thing, by the way, the law and the normative social realm have in common. They both rely on tradition. They both rely on consistency. So if the Supreme Court would change its mind every 2 weeks, we wouldn't hold it in very high regard for very long. The same holds for our moral codes. If whoever are those in charge, the public intellectuals, the ethicists, the religious leaders, if they would every 2 weeks take a different position, they would lose their standing. So the default is keep things the way they are. There has to be a sufficient challenge, like a 9/11, to us to agree that we should recast law and the normative side. So that's the first step. Is there enough of a challenge? And in what direction is it pushing us? Toward more privacy or toward more concern for the common good? The second step is, can we solve the problem? So voluntary means so we don't have to rely on legal and normative changes. Can we, for instance, encourage people to voluntarily have HIV tests rather than mandate it? And to the degree we can treat the pandemic that way, we're making progress without requiring changes in the balance between privacy and the common good. And the third, which I think very few people would object to, and seems to me, as far as I know, quite comfortable to legal scholars, is that if we have to make an intrusion, there will be a minimal intrusion. And the fourth one, which I maybe not as often mentioned, is that all intervention have undesirable, unexpected side effects. And therefore, responsible intervention soaks up these side effects. To go back to the HIV babies, we need to be sure that those medical records are properly sealed and accessible only those who have give medical treatment, and not to the insurance companies, to jobs and housing. And I added a fifth one for this occasion, and I don't have the right name for it yet, so anybody wants to send me an email. Or, I temporarily call it the horse and buggy rule. The horse and buggy rule is that if the criminals start using cars, you should not insist that police will use only horses and buggies. Means as we get technological advantage, like GPSs, which the criminals use, we should not ban the police from using it. And again, we could have a long, rich conversation on that. But it illustrates my second point, that we should move beyond the expectation of privacy and rely on these five criteria, to sort out what is reasonable and what is unreasonable. As to balance between oversight and that needs to be overseen. I find one example helps me think that's true, and that is the easy passes. I assume you have easy. One issue with the easy pass is how long does the toll booth or the port authority keep the information? And you can go from two extremes. You can go, it immediately erases the tape the moment it established that you did pay, or it can keep it for 10 years and feed it into the with all the other information about you and make it available to divorce lawyers. So you can have the full continuum. And that's the way we usually discuss it, as is privacy well protected or is it not, and everything in between. But I'm arguing there's one more step you have to think about. Can you trust the port authority what it tells you? So it's not enough for the port authority to tell you, I put my hand on my heart and I swear to you that I erase it 5 minutes later. The whole our government system is based on the idea, as President Reagan put it, trust but verify. And so the question is, how do we do that? And we have built into the government mechanisms like inspector generals and supervisors and such, whose job is to verify the rules. But in the end, I do believe that we need an independent citizen privacy review board, just the way we have police review boards. So we'll take deans of law schools and from distinguished universities and impanel them somewhat like the 9/11 Commission, which once a year will go to FISA and all those places and not discuss with us details, because the detailed cases, because those often may involve sources and methods, but give us an overview. Did the government use its power as declared or not? And if it abused it, where should we go from here to make it adhere more to the declared guidelines? I have, for me, again, a very telling example what happens when you do that. At one point, President Bush declared that the Patriot Act helped solve 400 terrorist cases. And the Washington Post got a list of those 400 cases and analyzed them. And they found that 200 of the cases had nothing to do with terrorism in the first place. And the other 180 were so mild that they barely deserve discussion. Example, there was an 18-year-old teenager in San Francisco who missed her boyfriend. So she sent a fax to a cruise ship captain and said, if you do not return to San Francisco immediately, I'm going to blow up your ship. And it was classified as a threat to mass transportation. And so that was one of the 400 cases. So in short, that review suggests to us that the claims that this particular step was not justified because it did not help us solve 400 terrorist cases. It may help if it's 20. I'm using as an example what such an independent privacy review board would tell us by looking statistically, rather than case by case necessarily, into the way the government does or does not live up to its commitment. So in general, we can give the government more power if we also get more oversight to be sure that it uses the power in line with its commitment. And to the last point about the need to protect sensitive information and protect the use of insensitive information in order it not be used to divine that what we didn't want to be disclosed in the first place. I think it's fairly clear by itself, and if it's all right with the chair, I'll stop here and use the last 10 minutes for discussion. I really appreciate that, because that's the part I get to learn. So.
Dr. Etzioni, if I could ask you to repeat any questions so the microphones will pick them up, or overflow room listeners would appreciate. Feel free to recognize questions.
Comments. Corrections.
I wanted to follow up on the horse and buggy rule. You discussed the GPS thing. I assume we're talking about the decisions that the police can put a GPS on your car without a warrant. You've also talked about tracking back and forth between private and government. Do you think it, as an element of that rule and as an element of us tracking government, should a private citizen be able to put a GPS on a private citizen's car? If the police can do it without a warrant, why can't I do it to the dean right here?
The question, again, if I do injustice to the questions, please correct me. If I favor that the police should be allowed to plant the GPS, how about a citizen being allowed to plant the GPS on another citizen? I must admit, this whole question of what our rights of privacy are against each other, the kind of peeping Tom issue, or against corporations, I find extremely confusing and unclear. I read a little I can find about it, and it seems to me like a uncovered turf, and so I don't even begin to know where to go with that. I want to add a sentence, though, to the GPS issue. I think the criteria we need to introduce here is not simply, does it or does it not violate an expectation of privacy, or is it to the home or not to the home? I think we need to know the scope and duration of the information collected and its sensitivity. The scope, duration, and sensitivity. So, for instance, Microsoft is now introducing to New York City a domain awareness system, which will take the CTV feeds from all over the city and from all the readers, the radiation readers and license plate readers, and put it all together in one profile. What that means, I mean, the increase in violation of privacy is many thousand-folds. They may not be completely obvious, because if you go to a bar and it has a CTV, that bar owner will know you were there 3 in the morning when you told your wife, you know, you were at a political meeting. But that's it, right? But the New York system will know all the bars you've been, all the political headquarters you visit, and you know practically everything about your outdoors. Or the phone tracking system, when somebody checked, over 6 months they had 36,000 places you have been. So I'd much rather you measure the heat in my kitchen, in my home, than track everything I do out of doors. So this all distinction, I think, we should replace inside, outside. Privacy is a bubble and not a 4 walls. And so the question is, how much information are collected, how duration, and how sensitive. I didn't answer your question because I'm not ready.
That's good enough answer. Thank you.
Thank you. One fact, and that is taking the train and walking from probably every step of my walk was under surveillance. And you have no surveillance in this. My question, however, goes to what appears to be your tilt towards the common good as opposed to lesser extent expectation of privacy. And my concern is this, and I think we all share it, anybody who's trying to battle with ComEd or with utility over a mistaken bill. The assumption is that when you, in this computer age, you have facts and you have information that is deemed to be absolutely accurate, but in fact it's not. And unfortunately, when you get to the point of disproving facts of that particular situation, the common good is not served, and you may be very poorly harmed by this. And so I'm wondering, in this age of automation and computer, a lot of times, how do you reconcile a lower expectation of privacy with these more invasive techniques?
Well, again, I'm serious. So I try not all the time, but I'm serious now. I don't know what expectation of privacy means. I can't think, nothing in my mind, it doesn't bring up anything other than confusion. So I wouldn't use this as a criteria. I think your criteria wants to be, is there a problem? Why should I make changes which are costly in many ways, morally and humanly and economically, unless there's a problem? So I can't go on without you telling me what is the problem. If the problem is inaccurate information, I want to do what we did try to do to the credit card, to the credit bureau people, and tell them they have to make change and so on and so on. It's not good enough. But so I want to deal to make the information more accurate, but I don't want to throw out the baby with the bathwater. I want to have credit scores because they improve good behavior. And so I think we should use those 4 criteria and forget about the expectation because it's a meaningless phrase.
Should be proactive. So you use the 9/11 example. Something like that, then the government should react. But what about when they anticipate? Fire, you're going to get burned. You know it's going to be a natural consequence. So someone has to get burned before the government should step in and say, now we need to protect this person. Writing was on the wall.
I was asked if we should be proactive or reactive if the government claims there's a threat. Some people call it fear-mongering. And if we should, if that's enough of a move to start recalibrating the balance between rights and the common good. And I think it's a very fair and severe challenge. And I know it's hard to believe, but so give me the year 7 in the White House, there was this concern that killer bees were coming from Mexico. And people wanted to do all kinds of things to stop the killer bees. I think it was a good idea not to move too fast. I think we need to have mechanisms to sort out threats which can be substantiated or not. I think the fiscal cliff is a threat given 2 hours I could substantiate. I think there are several others which, when you ask me to substantiate the danger of the deficit, I'd be on a less sure ground. And so I think there are established mechanisms which are not fully reliable like the RAND Corporation or expert courts, which can help us sort. It's an accountability issue. The real threats from imagined threats, and it's essential. But I also would say that you have to be proactive and not only reactive, especially when you come to weapons of mass destructions in Pakistan and terrorist issues like this, or even you talk about cyber attacks. Professor Swire.
Thank you, Amitai. What a wonderful talk. I have 2 questions or comments about your first point, privacy. One is something I'm sure you have a wonderful answer for. Social nudges are wonderful when it's stopping the child from throwing. If the social nudges are you can't be gay, you can't be different, then that starts to feel very. Talk about the pros. The second one, which is really welcoming to the approach, is policy discussions. There's a lot of talk about market failures. Also a lot of discussion about government failures, the way bureaucracies go wrong. But in those literatures, at least I've seen, there hasn't been as much discussion. Private, and maybe, quite possibly in your own writings or in other places, where would those of us interested find a sort of catalog of the social failure to try to build on that, to try to encourage those intermediate institutions?
So there are 2 questions raised. One, what if the informal social controls lock in on things which we morally or legally judge are inappropriate, like gayness? And the second was?
The second is, how would we start to catalog or see what.
Oh, there's a good source for discussion of social failures. On the second one, let me take the second one, it's easier. There is a fairly rich sociological literature. Robert Putnam, Bob Bella, The Habits of the Heart. In effect, any place which is not touched by economists is if you, forgive me for this one. I could possibly go to law school, not do that. But if you simply look at communitarian, even Etzioni, The New Golden Rule, and The Spirit of Community, or Britannica on communitarianism, you find a lot of discussion on it. What they all show, or should at least, is that you can go overboard in both directions. In fact, Amy Gutman said a communitarian wanted Salem without witches. And so the idea was we want social pressure, but not too much, not too harsh, and certainly not on the wrong issues. So part of the moral dialogue is exactly what is not appropriate. Though I must say, I believe in that line, and that sticks and stones will break your bones, but words should not hurt you. And so if people want to express their views, including this nut in California, or people who think you should not be gay, I would like to have them an opportunity to express it. The good news is that Americans move, the average American moves once every 5 years. To the very large extent, even those of us who are not particularly affluent, choosing which community we live and what kind of gated communities there are, what kind of rules they have, and so on and so on. And so we need to express that's going to be my last one, I see. We need to ensure that we will have communities in which people can follow those social rules which they morally approve of. Thank you so much.